Hi, and welcome to our third session on human resources management. I'm Charlie Domville-Lewis. I'm a Senior Education Officer at the Labour Relations Division of the Department of Commerce. Now, we're looking at a whole series of different employment law issues in these episodes. Last week we looked at employment status, and today we're going to look at a whole raft of things. We're going to look at awards, agreements and contracts, and also, I suppose, the induction process and starting out correctly. So we're going to look at defining the job when you identify an area that you want to fill at your business, the interview process, the obligations of an employer to their staff and of staff to their employers, and also the steps in putting in place a contract and some things to be aware of there. At any stage, please feel free to call in with any queries that you have, whether it's about specifically what we're dealing with today or any other areas of employment law. The number is 1-800-678-208. Okay, so first up, defining the job. So this is when you identify, I suppose, an area in your business that you want to fill, and you've got to look at the duties that that job is going to do, the skills that that person is going to require to fulfill those duties, and also you've got to think about the personal attributes that you value as an employer. Now, these might all sound like very basic things, but I think it's very important to be very clear on them from the very beginning and to define them. So if we look at an example of perhaps a specific duty that you might want to fill, say you're looking at someone to fill a receptionist job. You might want them to answer the phones or deal with customers. So the skills you're looking there at are communication skills, whether that be written or oral. And while with personal attributes, it's very much a personal thing about what you value, and there is no right or wrong answer in terms of what you value. You'll often find that the personal attributes that you want in someone will be related to their skills and the duties they have to fulfill. So, for example, if you wanted someone to have good communication skills, that's generally going to speak to someone who is positive and personable, friendly and polite. Other things to consider when you're defining a role is things like the physical requirements of the job. Are they going to have to do any heavy lifting? Are they going to have to do anything that requires exertion of any sort? Are they going to need to drive or anything like that? Do they have a driver's license? Do they have the other skills that aren't directly related to the job that are going to help them do it properly? And also anything else that's specific to your business. So we're going to go into a bit more detail about the specific requirements of your business and specific areas to be aware of in, say, an employment contract or a job description a little bit later in the session. Okay, so once you've actually advertised the job, you've clarified exactly what you want to do and what you want the employee to do, you have to obviously go through the interview process. So this is a really important area, and this is something that within half an hour or so, you're going to have to decide whether someone is suitable for the job, whether you can get along with them, whether the relationship is going to work out. So it's very important to be very prepared for this. If we want to look at certain areas of the interview process, the resume. Read this thoroughly of any applicants and ask specific questions about previous jobs. It's very easy for someone to talk in a general and abstract way about the kind of employee they are and the kind of skills that they have. But if you don't ask them about specific examples of those skills and those experiences, it's very hard to verify exactly whether they have them or not. And also avoid discriminatory questions. I think there's a big misconception about what constitutes a discriminatory question. People often are worried about having legitimate concerns about someone's ability to do the job because they think it might be discriminatory. So an example of this might be they don't want to say someone has a disability. It's obviously completely illegal, and rightly so, to not consider someone's application solely based on the fact that they're disabled. But it isn't illegal to have a job that requires certain physical exertion that someone with a particular disability may not be able to perform. So it's very, very important that you phrase any questions of that nature in the correct way and in a sensitive way. The other thing to consider is the role that you play in this particular system and this particular conversation. Remember that an interview is a conversation. You have a responsibility to tell the job like it really is, to represent the job accurately, honestly, and clearly. An example of this would be, for example, at my current workplace, the first job that I did was I was the receptionist there. And they were very, very clear from the very beginning that it was quite a slow reception, that it wasn't a particularly bustling job, and that there wasn't going to be a lot of responsibility to that role. At the time, that suited me. I was studying. It was good for me to have a fairly easy, fairly low-key job. But I think if they'd presented it incorrectly and said that I would be worked off my feet, that I would learn a huge amount doing this job, I think it would be much more likely that I would become dissatisfied and not done the job as well as I could have. So it's very important to be very clear and very honest about the job and be upfront about the challenges of that job from the very beginning. All right, well, that basically covers my spiel on defining the job and getting the best out of the interview process. If you've got any questions about that particular area, please do call on 1-800-678-208. Okay, moving on now. Another thing to be aware of as you're defining the job is the basic common law obligations that you as an employer have to your staff, and also that the staff members have to you as an employer. So firstly, your obligations. Two very simple, very straightforward ones: to pay the agreed wages and to provide work. An employer has to provide the wages that they've advertised as the minimum rate of pay for that particular job. And also you have to provide the work that you've said. Again, this comes back to representing the job accurately and clearly. If you're going to offer a certain pay rate and offer certain duties, you've got to make sure that you can then provide that to your employees. Also, you have a duty of care. Now, this really relates to work safety. You have the obligation as an employer to provide a safe workplace. There are no avoidable hazards, that everyone has all the right safety training that they need, that you have all the right safety policies in place that your business requires, that everyone, if someone requires, say, if someone requires protective gear, that they have that. If they require certain training to work certain machinery, that they have that training, that there are no avoidable hazards occurring in the workplace. That's on the physical level, but it also has to be a mentally safe workplace. So as an employer, you're obligated to make sure that there is no bullying or harassment or anything of that nature happening in the workplace, and that if it is occurring, that you stamp down on it as soon as possible. You also have the requirement to reimburse any expenses that an employee incurs while doing the job. So if they incur any kind of costs while doing the job, you have to make sure that you reimburse those costs. All right, now we're going to look at the employee's duties. So these are the basic common law employee's duties that every staff member has to their employer, regardless of where they work, regardless of their employment status, regardless of the system that covers the business. The first among these, one of the chief ones, is confidentiality. So that is the requirement to keep any sensitive information, anything that is confidential to the business, to themselves, not to disclose that to any rival businesses or to anyone that might harm the employer's reputation or the employer's business. So that could be any number of things, whether it's, say, the future plans of the business, the marketing plans of the business, or any sensitive information that the business deals with. The employee is required by law to keep that information confidential. They've also got to account for any money that they receive. Like a lot of these, it's the flip side of one of the employer's duties. The employee, if they receive any money from their employer to, say, buy supplies or equipment for the workplace, they have to account for it. They have to provide receipts. They have to be able to demonstrate that they did with the money what they were required to do with it. The other areas are that they exercise what's called reasonable skill and care. And again, that's the flip side of the employer's requirement to provide a safe workplace. An employee has to make sure that they do follow all the safety procedures, that they do wear any protective gear that they're required to do, and that they don't cause any accidents or hazards for themselves or their co-workers, and obviously that they don't bully or harass anyone else in the workplace. And the flip side of the employer's requirement to provide them with work is that an employee has to obey lawful commands. What that really means is that if an employer asks an employee to do something, if it's within that employee's training and is related to the work that they do every day, more often than not, that employee has to then follow that lawful command. Okay, so that basically does it for an employer and employee's duties to one another. Again, if you've got any queries about that, if you want any clarification on those matters, please do give me a ring on 1-800-678-208. Okay, now that we've defined the role, and now that we know exactly what the employer and the employee have to do for one another, let's look at the contract of employment. So these are the steps that you've got to follow when you're putting in place a contract. The first is to ascertain, does an award or an agreement apply to the business or the employment relationship? Now, I do understand that's quite tricky at the moment with community resource centres, but it's still very important to be aware of any minimum rates of pay that do apply to your business and make sure that the contract doesn't circumvent that, doesn't go around that. And also that it lists the employment conditions of the particular business and the particular role that they are doing in a clear and concise manner. Again, like with anything in the employment relationship, you've got to make sure that it complies with the Minimum Conditions of Employment Act. Now, I've talked about this a bit in previous sessions. The Minimum Conditions of Employment Act is the minimum safety net that all employees have covering them in the West Australian system. Any contract has to make sure that it does not go below any of the entitlements in that particular act. The same way that you can't sign away as an employee, you can't sign away any of your minimum entitlements. The step from there is to then draft the employment contract. So draft out the conditions, draft out the particular role, then discuss that with the employee. Both parties will sign it, and both parties keep a copy on file. It's very important to keep your copy, and also obviously to make sure that the employee has a copy, so that everyone has a very clear idea of what's required and everyone can refer to the document if there are any particular disputes. So what role does a contract actually play? A contract is a little bit different to, say, an award and agreement, where an award applies automatically and an agreement is a legally binding document. A contract is slightly different. A contract is still a legal document, but it is not one that is registered with the government in the same way that an agreement would be. And again, like all areas of the employment relationship, it cannot be less than the Minimum Conditions of Employment Act, and it cannot be less than the award if that is what applies to the employment. Essentially what that is saying is that no one can sign away their basic minimum entitlements under legislation. Any attempt to do so will have no legal effect, and you could get into quite a lot of trouble for doing that. So in terms of what someone might want to include in a contract, there's a few different areas. You might want to look at, say, the probationary period that you require for this particular role. Most awards will set a minimum probationary period of, say, 3 months. But you may wish to set a longer period if the role required is a little bit more complicated and it will take you longer to assess whether or not they are suitable for the role. You might also want to look at any additional remuneration that the role offers. So if you're offering the employee, say, money to park their car or to cover their expenses, if that's going to be a regular feature of the employment relationship, it's probably a good idea to set out in writing exactly what that remuneration is going to involve. If the working arrangements are going to be slightly unconventional, so they're going to work more, say, evenings or weekends or overtime, it's probably, again, good to set all that out in a contract. What I should probably mention at this point is that there's no legal requirement to have a contract in place, but it is a very good practice to have a contract in place. It makes sure that everyone knows exactly what's expected, everyone knows exactly what the role it requires, and exactly what everyone's going to receive for doing that particular role. Other areas to look at, and I'm going to go over this quite briefly because these are complicated areas, but other areas that may be included in a contract might be any intellectual property that the employee is going to have to deal with that belongs to the business. Restraint of trade, now that's basically a clause that restricts the amount of work that they can do in a similar industry with competitors if they ever leave the business that they work for. Confidentiality clause. Now, if you are going to be dealing with sensitive or confidential information on a regular basis, it does no harm at all to clarify exactly what those requirements are with regards to confidentiality. Use of email and internet. Now, I'm going to go into a little bit more detail on that in just a second, but we feel it's very important, especially now, to have clear policies on that, and also use of any other business resources. So if you're going to provide the employee with, say, a car or with a phone as part of the job, clarifying exactly what constitutes appropriate use for that and exactly what their responsibilities are in maintaining that equipment or those particular resources. Okay, now internet and email use. Again, I'm going to quickly just stop and say anything you wish to clarify with this, please do give me a ring on 1-800-678-208. I'm more than happy to answer any questions that you've got. So I just brought up the notion of email and internet use. Now, we're going to have a whole session in a couple of weeks on issues such as this in the workplace, things like social media, internet use, email use in the workplace. But I do want to bring this up quickly as something that you really do need to have some policies on as an employer, because more and more we're finding that things like social media and the internet in general, the way that people use this is growing and changing at a speed that legislators can't really keep up with. We can't make laws for these things because they're changing too quickly. So it's very, very important in lieu of those laws to have very clear, very well communicated policies in place. A very high-profile example recently of why you really need you need to have good policies in place is that of the Linfox case. I don't know if you caught this. I've sourced this from the ABC website. The transport company Linfox had an employee who'd worked for them for 20 years. He set up a Facebook account and made some rather tasteless comments about a couple of his managers on that Facebook account. He wasn't aware of how easily that information can get out. It got to his bosses and he was sacked. He appealed that. He went to Fair Work Australia to make a claim for unfair dismissal, and he was successful. Now, one of the main things that the industrial empire cited in terms of why the employee got away with making what could be described as quite tasteless comments about their employer on the website, why they got away with that, is because, and I quote, they found that the company did not have a social media policy and its induction training materials were inadequate grounds to sack the employee. Essentially, that meant that they had not made it clear what they required from their employees in their conduct outside of work when it came to things like Facebook or Twitter or MySpace. They had no policies in place, and therefore the employee had not breached those policies, and it was considered inadequate grounds to sack the employee. Now, the other thing that Fair Work did say in their decision is that that's not going to be a valid excuse for much longer. An employee's ignorance of how easy it is for that information to spread will only cut it as an excuse for so long. But it's still very, very important from the employer's perspective that you have very tight, very clear, very well argued policies on these things, because that is one of the first things that Fair Work or the West Australian Industrial Relations Commission is going to look at if a claim comes to them. All right, now just to quickly cite that article that I used, I got that from www.abc.net. It was written by Simon Cullen, and it was from October 3rd, 2012. All right, guys, that basically covers it for today's session. Again, if you've got any queries about anything I've talked about, please do give me a ring. The number again is 1-800-678-208. Now, we can talk about, obviously, what I've talked about today, but if you want to have any questions about, say, employment status, awards, agreements, please do feel free to call. As usual, I'm going to end by plugging WageLine. I'm going to sound like a broken record on this one, but WageLine is a free, unbiased, and confidential service. You can call them for any areas of employment law that you want to check. The way that I often look at it is that if they're not the last people you talk to, they're going to be the second last people that you're going to talk to, because they can always refer you to the right people if you've gone to the wrong place. They can clarify any areas that you've got, and as I say, it will remain confidential. It won't go any further than you and the person that you talk to about it. Okay, guys, so that basically covers it for today's session on induction and starting right and employment contracts. We're going to give it a few minutes now. If you do find that you've got any queries, please do call in. There's no legal requirement, I suppose, to specify anything in a contract about that. Obviously, it does help to be as clear as possible. Generally, what we find with part-time employment is that the contract will say you will work this number of hours every week, and I'm sorry, I'm looking at the speaker that the question is coming from. My apologies, Jody. That you would clarify exactly what hours someone is going to be working every week and the days that they're going to be working on. If someone's working part-time, generally that's going to be regular and ongoing work, and it's going to be the same hours every week. Does that help kind of clarify your query?
Yes, and if that, for example, if the part-time employee has to change days, for example, to cover or relieve another staff member that may be on leave, how does that work? Does it have to be written in to say that you may be required to work on different days to what is stated, or what do you have to do?
Okay, yeah, it certainly wouldn't be a problem to clarify, say, in the contract that these are the hours, and then maybe additional hours as required. That wouldn't be a problem to put into a contract. I suppose it would depend on how long that change was going to occur for. That would change how formal the contract had to be in terms of dealing with it. But I think certainly saying additional hours as required would be fine.
Okay, thank you very much.
No problem. Thank you very much for calling, Jody.
Bye-bye.
Bye. Okay, so I'm going to probably just quickly summarize what we've talked about today. And again, please do feel free to call if, like Jody, you have some queries. So today we talked about largely the induction process, I suppose. We looked at defining the job, making sure that you're clear on the skills and the duties that the role is going to require, and also the personal attributes that you value in an employee. We looked at the interview process, making sure that you ask the right kind of questions so that you can drill down to those skills and those experiences, and also you can find out a bit about the personal attributes that you value in an employee. We looked at the employee requirements for an employee when they work at a business, and also the employer's requirements to their staff, which will apply regardless of the system that applies, regardless of the award or the contract of employment. And we also looked at the steps that you've got to follow when you want to put in place a contract, and why it's very important to have a clear policy on things like email, internet use, and social media. So again, we'll give it a few more minutes, and if you've got any further questions, please do feel free to call. All right, well, thank you very much for tuning in, guys. Thank you, Jody, for calling. That's going to do it for me for this week. Once again, I'd like to just plug WageLine just one last time for this week. Please do feel free to call them at any stage if you've got any queries about employment law. So as I say, that's about it for this week. Now, please do join us on November 6th. We're going to be looking at some of the other agencies that you might want to call apart from WageLine that deal with employment law matters. So we're going to look at, say, the tax office, superannuation, areas like that, who you need to call for clarity on those particular laws. So once again, if you've got no further queries, thank you very much for tuning in, and we'll see you then.